sent to the Attorney General on April 30th asking for all communications with Mr. Colangelo, with the Justice Department and the folks in the Manhattan District Attorney's Office. So without objection, that will be entered into the record. The chair now recognizes the gentleman.
Concerned about the prospect of committees of Congress obtaining confidential records from Justice Department of criminal investigative files for the purpose of addressing highly politicized issues. Is that correct as well?
Are you citing my letter?
Yeah, in the letter
that's correct. Yeah.
Right. So let me go back. In the United States versus Mitchell, during the Watergate District Court case, Judge Sirica held that by releasing portions of a subpoenaed recording in transcript form for publication, the president's claim of confidentiality and that privilege associated with it was no longer valid since the conversations were no longer confidential. You produced the transcripts to this committee, correct?
Yes.
And prior to producing the transcripts to the committee, they were leaked to the press. So based on Mitchell, which is still good law, the recordings are, in fact, no longer confidential, aren't they?
Can I respond? I'm sorry, that's not what Mitchell was about at all. Mitchell was, first of all, about transcripts created by President Nixon, for which there was plenty of reason to believe that they were not accurate. And secondly, it had to do with the confidentiality of communications between Nixon and his staff. And once he provided the transcripts, the court said those communications were no longer confidential. That is not the allegation. That is not what we're asserting here. Here we're asserting confidentiality over the audio, not confidentiality, but protection of the audio in a criminal investigation, an interview, not a staff meeting.
Okay, thank you. Let me move on. Your May 15th letter also relies on the argument that producing the audio tapes would affect the department's ability to obtain vital cooperation in high-profile criminal investigations, in particular in investigations where the voluntary cooperation of White House officials is exceedingly important. Is it your testimony that a White House official would voluntarily cooperate in a criminal investigation only if the Justice Department promises not to release the audio recordings? It doesn't make any sense.
The long-time experience of the Justice Department, is also reflected in the declaration that was filed under oath, is that witnesses want to protect the confidentiality of their communications with the prosecutors during these sensitive interviews. In the Cheney case, the Justice Department made the same claim, even with respect to FBI notes about interviews of Mr. Cheney and that special counsel. It's our view that we need witnesses to be willing to be tape recorded or audio recorded, and that they are going to be less willing to do that if they know it's going to be made public. In the declaration that was filed in court on Friday, the senior official stated that he knew of cases right now where people are unwilling to provide audio because they are worried about it becoming public. So the answer is yes, that is our view.
Attorney General, have you listened to the audio recording?
I have not, because there's no reason for me to listen to it in order to make the determinations that I had to make. We had the special counsel describe in detail his explanations for his determinations.
So let me, I don't understand how you can kind of sit before the congressional committee and kind of arbitrate what's indistinguishable from the transcripts if you're not even sure what's on the tapes themselves.
I'm not doing it on my own. I have.
So you're saying other people have listened to it within the department?
Within the department, and the special counsel has listened to it, and the special counsel had every interest in ensuring that the transcript that he produced in order to do his investigation would be accurate. Yes, that's right.
Okay, so let's go back. So in May 15th letter, you also attempt to distinguish the committee's reliance on the United States versus Nixon. Specifically, you claim that since President Nixon had released only edited transcripts of a portion of the meetings covered by the audio recordings, the Nixon case does not apply. But that was not what the court held regarding the enforceability of the special prosecutor's subpoena, was it? That doesn't match up right now then.
I'm not exactly sure what you're asking. That Nixon, it was well known that Nixon had edited the tapes, had edited the transcripts, and he said he had edited the transcripts. That is not what happened here. The special counsel, the FBI agents in a room, and the senior career official said that the transcripts matched the audio.
So the court reasoned that the audio recordings would be relevant to show, among other things, a criminal conspiracy and for other valid potential evidentiary uses for the same material.
In the Nixon case, yes, because there were parts of the transcript in which the conspiracy was disclosed of those communications, which parts of the audio in which were not in the transcript. That's not the situation here. Here,
We don't know that, though, Attorney General. We're unaware because we haven't heard the tapes. We don't know if they match up.
everyone had a genuine reason to believe that those transcripts were not accurate. Here, you have the special counsel, you have the FBI agents in the room, and you have the senior career official in the department all comparing it and finding them to be accurate.
Time of the gentleman has expired. The gentleman from Georgia is recognized for 5 minutes.
Thank you, Mr. Chairman. Most Americans have grown sick and tired of this do-nothing MAGA Republican House of Representatives, which has failed to pass a single piece of legislation that lowers costs for families or addresses the southern border issue or other important issues. Instead of attacking real issues that matter, House MAGA Republicans fritter away time with rabbit hole investigations of Dr. Fauci and Hunter Biden, while simultaneously spinning webs of lies that seek to create public wrath against anyone who would dare to be involved in any effort to hold convicted felon Donald Trump accountable for his misconduct. The American people can see right through these distraction efforts. Attorney General Garland, thank you for your many years of service to our nation. Among other positions in the federal justice system, you have had an illustrious career as a federal judge, a judge of the United States Court of Appeals for the District of Columbia Circuit from 1997 through 2021, including as chief judge from 2013 to 2020. And you also served as chair of the Executive Committee of the Judicial Conference of the United States from 2017 to 2020. So I'm sure that you've had a lot of time to think deeply about the importance of judicial impartiality in a functioning democracy. I and 44 other members of Congress have called for Justices Thomas and Alito to recuse themselves in cases where they cannot be seen as impartial in the case seeking immunity for Donald Trump and others. Justice Thomas's wife played a major role in the Stop the Steal movement that culminated in the January 6th insurrection, and we recently learned that Justice Alito flew flags related to the Stop the Steal movement at both his residential home and his vacation home in 2021 and again in 2023, which directly ties him to the January 6th insurrection, to Donald Trump, and to efforts to overturn the 2020 election. We urged them to recuse themselves from related cases, and Justice Alito last week refused. Then last week, my colleague Jamie Raskin wrote an op-ed arguing that DOJ could petition the other 7 justices to require Justice Alito and Thomas to recuse themselves. That leads me to this question. Is the filing of such a petition with the Supreme Court something that the Department of Justice is considering?
I'm afraid I'm going to have to give you the same answer I've given to other members. The Justice Department can't comment on matters that are before a court, matters you're talking about before the Supreme Court.
I'm talking in terms of an independent petition, not related to any matter pending before the court at this time, but related to those matters.
Justice Department speaks through its filings on matters before the court, and that's all I can say about it.
Well, I'd like for the DOJ to at least consider that possibility. My next question, public reporting has revealed that Supreme Court Justices Clarence Thomas and Samuel Alito have accepted gifts of luxury travel and lodging from billionaire benefactors and failed to report those gifts as required under federal financial disclosure laws. The Ethics in Government Act provides the Attorney General authority to investigate and take action against violations of the financial disclosure laws by members of the federal judiciary, even without a referral from the Judicial Conference. Is What can you tell us about Department of Justice efforts to investigate those high-profile violations by those two justices?
I'm afraid I'm going to have to say the same. As I said before, the Justice Department does not comment on whether it investigates or who it investigates or whether it should investigate.
Fair enough,
All of
sir.
our statements are reflected in court papers. And
Fair enough. Threats on the judiciary are increasing, and this is frightening to the rule of law. Can you talk about the work that DOJ is doing to address this important issue?
Yes, the threats to the judiciary, threats to prosecutors, threats to law enforcement agents have all spiked significantly, and in some cases have accelerated from threats to actual violence. We have a threats task force engaged in investigating these matters. We intend to aggressively investigate and prosecute threats against our public officials, including members of Congress, of which the numbers have actually exploded in the past couple of years. Our democracy cannot continue if the people who make the democracy run are afraid, if they make their decisions based on fear of being threatened or of being assaulted. No democracy can survive under those circumstances, and we will do everything we can in our power to investigate, deter, and prosecute anyone who makes threats against public servants.
Time of the gentleman.
Thank you. I yield back.
Gentleman yields back. Mr. Garland, why Jack Smith? Why'd you pick him?
Well, I've said at the time I appointed Mr. Smith, I explained he was independent. He was a longtime career prosecutor with.
But there are probably other people who you would describe as independent, long-time career prosecutor. Why did you pick? This is probably the most high-profile special counsel investigation, maybe in American history. You're going to be investigating a former president, a candidate for president, and leading in all the polls, and you pick Jack Smith, most important selection maybe ever made from Attorney General when you come to a special counsel. I just want to know why you could have picked
Well, I'm telling
former
you.
AGs, deputy AGs, U.S. attorneys. You got all kinds of lawyers in this town, but you picked Jack Smith.
All the people you just mentioned would be political appointees. I appointed somebody who was not a political appointee, somebody who was independent, nonpartisan, with a record of career experience as a prosecutor. That seemed to me the perfect resume for making that kind of.
He was a guy, worked, you had to bring him back from Europe. He worked at the ICC, worked at the World Court. He was the best pick for the most high-profile investigation ever.
He was independent. He was nonpartisan. He had never held a political office. He was never appointed in a political office.
Was he your first choice?
He had a long career as a career
Was he your
prosecutor.
first choice?
I'm not going to go into the questions.
Did you know him before you picked him?
I did not.
You never worked with him?
I did not.
Did you meet with him prior to announcing his selection and tell him what was going on?
Of course I did.
What happened in that meeting?
I met with him. I asked him if he would be willing to do this. We talked about my understandings of the role of this office, which are on the public record. That's all.
Did he ask for the job?
This is not a job I don't think anybody asks for. I'm sorry.
No, but that's not the question I asked you. I said, did Jack Smith ask
He
for
did
the job?
not ask me for the job, no.
Did he convey through someone else that he wanted the job?
I would be surprised if that were the case, but
Well, you don't know?
No, I don't know.
So he may have?
I can only tell you what I know. I chose him because he had a record of impartial career experience as a prosecutor. That's why he was chosen.
Was it impartial when he went after Governor McDonnell?
He was a member of
He was after Governor McDonnell. That case gets appealed to the Supreme Court. The Supreme Court unanimously said it was wrong and overturns the conviction?
He was in the public integrity section of the Justice Department, a career position. They made the decisions they thought were warranted, and we respect the decision of the Supreme Court.
Did the fact that he was interested in going after the very people who were targeted by the IRS about a decade ago, did that have any influence on your selection? Okay, let's put up this slide here. This is from Jack Smith to some other folks in the Justice Department, and it says, could we ever charge a conspiracy to violate laws of the U.S. for misuse of such nonprofits to get around existing campaign finance laws? Jack Smith was looking to prosecute the very people who were targeted by the Obama IRS.
I don't know. You have excerpts from an email I've never seen. You should know that I
IRS
sat...
Commissioner Sarah, I'm just asking, did this weigh into your decision? Did you know about this,
No,
what
no,
Jack Smith
I
was
don't
trying
know
to
if
do?
it's, I also don't know if it's true now.
IRS Commissioner Sarah Ingram oversees this from Jack Smith himself. Let's discuss tomorrow, but maybe we should try to set up a meeting this week. And here's the response. Here's the response. You didn't get your meeting with Miss Ingram from the IRS, but she's sending the head of the exempt organizations, Lois Lerner, who's known to us. So Jack Smith meeting with Lois Lerner, looking for ways to prosecute the very people who were victims of the Obama IRS. And I'm just asking, did that factor in your decision to name Jack Smith as special counsel?
I didn't have any idea about the things...
Didn't know about that.
No, and I don't know whether they're true now by looking at this.
But they're definitely true, but you
should
didn't know about
know-
it. But this guy was so important, you have to bring him from Europe back here to go after President Trump, name him as a special counsel. Do you regret the pick?
I'm sorry, I couldn't...
Do you regret picking him?
No, I do not regret picking him.
Well, prosecutors aren't supposed to tamper with evidence, and it looks like that's what he did. He changed the sequence of the documents that he seized from Mar-a-Lago.
I'm sorry, that's a false characterization, but that is ongoing.
Here's what he said to the court, Mr. Attorney General. There are some boxes where the order of items within the box is not the same as in the associated scans. I mean, he said it. I didn't say it. He told the court that.
Now you're asking me to comment on a discovery dispute that's ongoing in a court. I don't know the facts of it, and I'm not
No,
going to comment on it.
this is from Jack Smith filing with the court. He admitted to the court that they tampered with the evidence. He mishandled the very documents he's charging President Trump with mishandling. And I'm just asking, do you regret picking this guy as the special counsel in the most important special counsel investigation probably in American history?
I'm sorry, I did not hear the words tamper in the statement that Mr. Smith filed. He did not use those words.
Well, let me ask it this
I'm
way.
gonna
Are you
leave that
supposed to
to- I'm gonna
change the
leave that
order
to-
of the documents that you seized and the physical documents don't match up with the scanned documents? Are you supposed to do that as a prosecutor?
This is a matter in dispute, in discovery in that court, and I'm going to leave it for the district court to make a determination. After
I would just say one last
district
thing.
court makes
It's
a
not in
determination-
dispute. This is what he said in the court filing. Jack Smith's team said that to the judge in the court. By the way, this case is now basically on hold because they've screwed up so many things.
Again, I don't know whether your description of the facts are true or not true, and I'm not going to intrude in a decision in a district court.
Chair recognizes the gentleman from California.
Mr. Attorney General, we appreciate your being here. We appreciate how you have led this department with integrity and discipline and your enormous public service. I appreciate your willingness to sit through this endless cascade of false allegations and conspiracy theories and innuendo. The chairman began this hearing with the dramatic statement that justice is no longer blind. By that, he means that justice is no longer objective or impartial, that it is suddenly now a respecter of persons in the wrong way. That is, it will distinguish between people based on their position. But of course, the chairman's real problem is that justice remains no respecter of persons. That you can be the former president of the United States, but if you commit crimes, you'll be held responsible. That's his problem. That's the problem of all my Republican colleagues right now, and that is they're about to nominate a convicted felon. And they don't know how to cope with that. They don't know how to cope with the justice system that, in fact, treats Donald Trump the same as it would any other citizen. And so they have to push these conspiracy theories that they know are patently false. And they try to run over you with questions they won't let you answer, because their whole arguments are utterly insupportable and destructive of our justice system. They care more about this convicted felon than they do the country. I have to say I'm pleased and a bit surprised to see that the flag in this committee is still flying right side up, because they want to turn it upside down, even as they want to turn our justice system upside down. Let me address the conspiracy theory of the day, which is somehow President Biden, through your department, has convicted Donald Trump in Manhattan in an effort to weaponize justice against the former president. So let me just ask some basic questions about this phony conspiracy theory. Did you appoint Alvin Bragg to be Manhattan DA?
No,
Of course not. He's elected. Did you select the jury in that case?
the judge selected the jury.
Well, did you select the judge in that case?
No,
No, of course not. The judge was randomly selected. Did you select the jury in that case?
no,
The jury was actually selected by Donald Trump and his attorneys. Did you reach a verdict in that case?
no,
Did you instruct the jury in that case?
No,
Did you tell the prosecutor what charges to bring in that case?
no.
This was 12 ordinary New Yorkers who weighed the evidence and found Donald Trump guilty of 34 felonies. And instead of celebrating the fact that in this country, an ordinary group of jurors, an ordinary group of 12 people can still adjudicate a case involving one of the most powerful people in the country, no, they would denigrate the whole system. They would tear it down. In the service of this convicted felon, they would tear everything down. They would tear the house of this democracy down around them. They say it's unprecedented to bring charges against a former president. You're damn right it's unprecedented. We've never had a president of the United States who was making hush money payments to a porn star and then falsifying business records to cover it up. Yeah, that's unprecedented. We've never had a president withhold classified information and then obstruct the investigation. That is unprecedented. We've never had a president incite a violent attack on the Capitol. That is unprecedented. And you know what else is unprecedented? The fact that so many leaders of that party are perfectly fine with all of that. In their headlong pursuit of power, they're perfectly fine with that. They're going to nominate a convicted felon as their presidential candidate. And they have another conspiracy theory, which is when a search was executed of the president's residence in Mar-a-Lago, they went in, as the president said, locked and loaded and ready to take him out. Yet another dangerous falsehood. And your dedicated public servants at the Justice Department are having their lives threatened because of the irresponsible actions of people on this committee and in the Senate and elsewhere who would endanger the lives of those committed to enforcing law and order, even as they claim to be a party of law and order. Mr. Attorney General, I am grateful for your service, for your withstanding all of this. We will get through this because of people like you and the honorable public servants at the Justice Department. Mr. Chairman, I yield back.
Gentleman yields back. The chair recognizes the gentleman from Arizona.
Thanks, Mr. Chairman. Mr. Attorney General, the reality is Mr. Hur, Special Counsel Hur, found that then former Vice President, President Biden, had retained and disclosed classified information. Isn't that true?
Mr. Hur has presented a long report.
Isn't that true? I mean, come on. I'm practically quoting right from it. You wouldn't disagree with that assessment?
I won't disagree with I'm not going to comment on his report. He sets forth, I appointed him to investigate the allegations about classified documents.
So the reason that we end up talking over you is because a simple question like that goes unanswered. You're non-responsive. You're non-responsive to the question. Because that is what Mr. Hur found. And then he also found, and you're not going to like this because I'm going to quote from it. From this, he basically says here that he found Mr. Biden to be sympathetic and here he is, a well-meaning elderly man with a poor memory. And so he made a prosecutorial decision that he wasn't going to prosecute. Are you going to dispute that? You're not disputing that, are you?
Mr. Hur's report.
Okay, you're going to say it stands on its own. Okay, so it stands on its own. No, because you're not intent on answering. You want to be non-responsive. You want to filibuster.
I'd like to answer your question.
Do you dispute that? So let's just face it. Mr. Biden has not been prosecuted, correct?
That's correct.
And the rationale given by Mr. Hur is because he was a sympathetic, well-meaning elderly man with a poor memory, and he thought the jury would have sympathy towards Mr. Biden.
That was one of a long list of reasons that Mr. Hur gave for his decision.
Give me one more reason.
He found that, look, I don't want to get into a discussion about this, but I will say one of them was that the president was completely cooperative in this matter.
That's the reason, huh? Okay, all right.
You asked me one of the reasons. That was one of the reasons.
The issue that we have here, you don't want to give us the audio tape. You don't want us to have the recording. But ultimately, the issue is whether the transcript actually supports the special counsel's determination. Now, your office has basically pled two things in court, claiming, number one, executive privilege, and number two, this kind of interesting novel approach saying deep fakes, AI. Right, did they consult, did your staffer who filed that, did they consult with you about the deep fake AI rationale for not providing the audio to us?
You're mischaracterizing the filing. That was one of, again, a substantial number of arguments made in a Freedom of Information.
Did they consult with you specifically about that idea, that notion where they were going to say something like, quote, this is from the pleading, the passage of time and advancements in audio, artificial intelligence, and deepfake technologies only amplify concerns about malicious manipulation of audio files, close quote. Did they consult with you about that provision?
I'm not going to talk about internal department deliberations. That was one of a large number of explanations in the document you're talking about.
And I'm talking specifically about that particularized rationale, and you don't want to discuss it, which is why you're non-responsive, and that's why we need the audio. And let me explain why. Because your attorney also said that you did alter the transcript, and they said it was filler words, repeat words, and, I. But you know what? We don't know whether they're the blank, he said there were blank times where there was silence. We don't know whether those were 1 minute long, 2 minutes long. We don't know if he sputtered for and, because those were edited out. We do not know whether this supports and substantiates Mr. Herr's findings. By the way, you want to rely on Mr. Herr, you need to go back and listen to his testimony. Mr. Herr was pretty conclusive there that he had a poor memory. He was not able to answer all the questions. Substantively, the transcript may be accurate, but you know what? The audio would tell us so much more, which is why the Supreme Court, in the case that you poo-pooed when Mr. Fitzgerald was asking about, they said, look, you know, if there's editing that's gone on here, that's the rationale, and there was editing. Your own office admitted it, but you won't admit it today. You've been non-responsive, and that's why we need the audio, and that's why you're here. Yield back.
Gentleman yields back.
Mr. Chairman, I have a unanimous consent request.
Ranking members recognized.
Mr. Chairman, I ask unanimous consent to enter into the record the transcripts of Special Counsel Herr's interviews with President Biden. As you can see on the last pages, the transcriber certifies that the transcripts are true and correct.
Without objection, gentleman from Arizona is recognized for unanimous consent.
Thank you, Mr. Chairman. I also submit the pleadings in the case of Judicial Watch versus U.S. Department of Justice.
Without objection.
A document entitled DOJ Claims Unprecedented Deep Fake.
Without objection.
Transcript tampering. DOJ says written record of Biden interview with prosecutors omitted words.
Without objection.
DOJ refuses to release audio of Biden and the Herr interview.
Without objection. The gentleman from California is recognized.
Before anyone else on the other side saddles up and gets on their high legal horses, I just want to remind the committee that the chairman is 754 days into his own subpoena defiance. Mr. Attorney General, last week it was reported that House Ethics Panel subpoenas DOJ for Gates records. It was a May 14, 2024 political piece. I'd like to submit it to the record with unanimous consent.
Without objection.
I just want to get this straight. Mr. Gates wants the Attorney General to reopen and publicize evidence from an investigation that a Donald Trump-appointed prosecutor closed against President Biden, while at the same time, Mr. Gates himself is being protected by the same DOJ policy that is refusing to voluntarily turn over evidence from Mr. Gates' sex trafficking investigation. Mr. Attorney General, can you just briefly, without going into the facts of that case, address why that is the DOJ policy as it relates to the current president and any other requests about closed investigations?
Yeah, without referencing any case, we try to protect the law enforcement files of the Justice Department so that in future investigations, people are willing to cooperate with us. We understand Congress's concerns and we have an obligation to assess whether the information that we've provided is sufficient to accommodate the legitimate needs of the Congress. All of the reasons that Congress has given us for why they need the audio are satisfied with respect to the tapes. That is, all of the legitimate reasons given, the reasons that relate to legislative work of the committee. As to that, we've accommodated by providing the audio. We provided Mr. Herr's testimony in full, and we've provided Mr. Herr's testimony report. We've gone as far as we can go to accommodate. We're trying to protect our ability to do investigations in this case and in any other case.
Mr. Attorney General, let's set the facts straight here. And my job is to kind of lead an intervention for my colleagues. I think they need it. The Attorney General did not prosecute Donald Trump in New York. It was the result of Donald Trump's choices. Donald Trump chose to live in New York. He chose to commit his crimes in New York. He was afforded a right to be tried by his neighbors, jurors, in New York. He chose that jury in New York, working with his counsel, and they chose to make him a 34-time over convicted felon. But some of the choices the department has made in the recent years is that the president that was first appointed, that Donald Trump appointed the U.S. attorney who is investigating the current president's son. Donald Trump appointed John Durham, who investigated the wild claims made by this committee during the Russia investigation. And Donald Trump appointed Robert Hur, who was kept on by the Biden administration. Also, you have the right in our country to aid yourself in your own defense and talk to investigators. You also have a right not to. Mr. Attorney General, did Donald Trump sit down for an interview in the Mueller investigation?
I actually don't know, but I'm not going to comment on other investigations.
He didn't. Did he sit down for an interview with investigators prior to the January 6th indictment?
I'm not going to comment on
He
any
didn't.
investigation.
He also didn't sit down for an interview with investigators in the classified materials indictment, but President Biden did sit down for a voluntary interview with Robert Hur. A jury can't hold it against Donald Trump that he did not testify in his own defense in New York, but he promised everyone else in the country that he would. You can hold it against Donald Trump that he did not testify when you consider whether you should so blindly follow every wild claim that he makes. My colleagues, none of this today that you are bringing makes sense. Your inconsistencies, your hypocrisy, your sycophancy, unless you are in a cult. And guys, I'm starting to think you're in a cult. That is your right, but it's not your responsibility. I promise you that's not what your constituents would want. So if you believe in states' rights, except when a jury in that state convicts your nominee for president, you might be in a cult. If you claim you back the blue but want to defund the police when the police go to your nominee's house to retrieve national security secrets, you might be in a cult. If you're supporting a guy whose felony convictions prevent him from getting a security clearance, you might be in a cult. And if the guy you're supporting for president has felony convictions that prevent him from going to Argentina, Australia, Brazil, Cambodia, Canada, Chile, China, Cuba, Dominican Republic, Egypt, Ethiopia, Hong Kong,
my motion
India,
takes precedent.
Indonesia, Iran, Ireland, Israel, Japan, Kenya, Macau, Malaysia, Mexico, Morocco, Nepal, New Zealand, Peru, Philippines, Singapore, South Africa, South Korea, Taiwan, Tanzania, Tunisia, Turkey, Ukraine, United Arab Emirates, and the UK.
The gentleman from Kentucky is recognized for 5 minutes. I'm asking the gentleman.
I have unanimous consent request.
Gentleman has unanimous consent request.
I ask unanimous consent to submit for the record an amicus brief by the former Attorney General Edwin Meese.
Without objection.
The question presented is whether private citizen Jack Smith lacks authority to represent the United States. I also ask unanimous consent to submit for the record an article titled, "Was it legal to appoint Jack Smith in the first place?" This is a Heritage publication.
Without objection.
I want to start by reading you the appointment clause of the Constitution. Article 2, Section 2, Clause 6 states, "The President shall nominate and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. Are U.S. attorneys nominated by the President and confirmed by the Senate according to this appointments clause?
They are appointed by the President and confirmed by the Senate.
Wouldn't you agree that U.S. attorneys are held to the appointments clause because they are delegated some part of the sovereign power of the United States, such as the ability to make indictments and charge individuals with crimes?
I would say that those are not the reasons why, and a court has already ruled on the question of whether special counsels are subject to the appointments clause in the Mueller case, and ruled that they were not. Was
Jack Smith nominated by President Biden or confirmed by the U.S. Senate?
Look, you're asking me about a case, again, motions filed as you just
This
cited
is a
in
simple
another-
question.
No, I'm not
Was
gonna.
Jack Smith nominated by President Biden?
No, he was not.
Was he confirmed by the Senate?
No, he was not.
When was the special counsel statute passed?
There is no special counsel statute. There was an independent counsel statute that was expired.
So it expired. So what gives you the authority to appoint a special counsel? You've created an office in the U.S. government that does not exist without authorization from Congress.
There are regulations under which the Attorney General appoints special counsel. They've been in effect for 30 years, maybe longer, under both parties. The matter that you're talking about whether somebody can have an employee of the Justice Department serve as special counsel has been adjudicated.
You appealed, let me interrupt for a second, because you appealed to a regulation, a rule, whereas the Constitution says shall be established by law.
Yeah, the
statutes. Right, the statute, but you referred to a regulation, not to U.S. code.
May I answer? The regulation cites the two U.S. Code provisions that permit the Attorney General's appointment. Attorney General Barr cited to the same ones.
Are you familiar?
Even Attorney General Meese did that.
All right, are you familiar with former Attorney General Meese's amicus brief?
No.
You're not?
I know that he's filed one because I read it in the newspapers, but otherwise I'm not familiar with it. But
Well, he raises some good questions that I agree with in there. It seems like you've created an office that would require an act of Congress, yet there's not an act of Congress that authorizes that. And even if it didn't require an act of Congress, and you've already admitted it, there was no act of Congress that established this office, it would still require, according to the Constitution, a nomination by the President and confirmation by the Senate. I want to move on to January 6th. Is it accurate to say that the DOJ is on pace to arrest roughly one protester a day in 2024, nearly 3 years after the incident?
I don't know what the pace is. The job is to arrest and bring to justice people who are criminally responsible, and as they are found, they will be arrested.
Is your office preparing to drop charges against more than 340 January 6thers charged with 1512C2 and release dozens from prison on that count if the Supreme Court this month reverses how your department has used that statute against them?
We respect the Supreme Court. Whatever the court rules, we will act appropriately.
So you'll have to drop the charges if the Supreme Court says that you did that wrongfully.
I'm not going to answer hypotheticals. We'll wait and see what the Supreme Court says.
What do you say in response to D.C. Appellate Court overturning 2 excessive sentencing requests sought by your office?
I say that is a United States system of justice working. If people think that they have inappropriate sentences, they can appeal their sentences. That's the way our system works, and we respect the results.
So you've refused to answer questions before us, including my questions about January 6th on multiple occasions here in this committee, but the Inspector General is preparing a report. Are you in receipt of that report yet? He's promised to examine the role and activity of DOJ and its components in preparing for and responding to the events at the U.S. Capitol. Are you in receipt of that?
I'm not in receipt of any report. You'll have to ask the Inspector General.
Isn't it true that it will go to you before it's released for review?
I don't know about it will not go to me for review. The Inspector General is independent. I hope to see it before, but that's up to the Inspector General. Let me just remind you, I was not the Attorney General on January 6th.
Do we have your commitment to release that as soon as you see it?
The determination of the release of Inspector General reports is up to the Inspector General. We give them independence. Congress demands that we give them independence.
My time has expired, but we have your commitment not to slow down the release of that from the Inspector General?
Our Inspector General is a very independent person. There's no way I could stop him from doing what the law requires.
I yield back.
And I would certainly never do that.
Gentleman yields back. Gentleman from California is recognized.
Thank you, Mr. Chairman. The House Judiciary Committee is responsible for helping to ensure the rule of law. Unfortunately, the chairman of this committee himself ignored a bipartisan congressional subpoena. The actions of this chairman have made it harder for congressional committees to get information from witnesses and have hurt the rule of law. Thank you, Attorney General Garland, for your public service. I'm going to ask you a series of simple questions about past concluded cases to get the facts out to American people. The Department of Justice charged Donald Trump's former campaign chairman, Paul Manafort, in a federal court with multiple felonies. Mr. Manafort was convicted in a federal court, correct?
It's my recollection of what the public record discloses.
Public record shows he was convicted in a federal court. The Department of Justice charged Donald Trump's former deputy campaign chairman, Rick Gates, with multiple felonies. Mr. Gates was convicted in a federal court, correct?
Again, that's to my best of my recollection, that's what the public record discloses.
Thank you. The Department of Justice charged Donald Trump's former campaign foreign policy advisor, George Papadopoulos. Mr. Papadopoulos was convicted in federal court, correct?
Again, that's my best recollection of the public record.
You were not the Attorney General at the time, correct?
I was not, no.
In fact, the Attorney General for those three criminal cases was Jeff Sessions, who was nominated by Donald Trump. The Department of Justice charged Donald Trump's former lawyer, Michael Cohen, with multiple felonies. He was convicted in a federal court, correct?
Again, that's my best recollection of the public record.
You were not the Attorney General at the time, correct?
I was not.
In fact, Michael Cohen had two sets of convictions. The Attorney General for Michael Cohen's second conviction was Matthew Whitaker, who was also appointed by Donald Trump. The Department of Justice charged Roger Stone, who was an advisor to Donald Trump, with multiple felonies. Roger Stone was convicted in a federal court, correct?
Again, my best recollection of the public record.
Yeah. The Department of Justice charged Elliot Brady, who was a fundraiser for Donald Trump. Mr. Brady was convicted in a federal court, correct?
Same answer.
You were not the Attorney General at the time, right?
I was not.
Okay. In fact, the Attorney General for those two criminal cases was Bill Barr, who was nominated by Donald Trump. What these facts show is that the Department of Justice has not been weaponized. We have one Department of Justice that goes after criminals regardless of party affiliation. These Trump associates were convicted under the administration of three Republican attorneys general, each of whom was nominated by Donald Trump. Trump's campaign manager, felon. Trump's deputy campaign manager, felon. Trump's foreign policy advisor, felon. Trump's lawyer, felon. Trump's political advisor, felon. Trump's fundraiser, felon. It is not the fault of the Department of Justice that Donald Trump surrounded himself with criminals. Trump brought that upon himself. One of the things that makes America great is we are ruled by the law, not by a cult of personality. I want to thank you, Attorney General Garland and the Department of Justice, for applying the law without fear or favoritism. And I note as we sit here today, the Department of Justice is prosecuting Hunter Biden in a federal court right now. You can't love your country only when the candidate you like wins, and you can't love law and order except when the criminal felon is someone you like. In America, no one is above the law, not the rich, not the powerful, not any former presidents, and certainly none of his criminal felon enablers. Now I want to move on to another subject. Our gentleman from Arizona on the other side of the aisle gave away the game today when he said why he wanted the audio transcript. He said, we wouldn't know if Joe Biden had said and. So I just want to ask you this question. Special Counsel Robert Hur said that this transcript was accurate. The written transcript was an accurate rendition of the audio transcript, correct? Except for some stutters.
Yes.
So what the gentleman from Arizona wants is that transcript audio with the and. Because Joe Biden stutters. He's had a stuttering problem his entire life. He overcame stuttering. He was made fun of in school, and he overcame this disability to become president of the United States, a leader of the free world. And it is despicable that my Republican colleagues want to go after him for his stuttering problem. They should apologize, and I yield back.
Gentleman yields back. The gentleman from North Carolina is recognized.
Mr. Attorney General, you said earlier today you spoke to the committee's recommendation to the House to hold you in contempt. You said, but we have made clear that we will not provide audio recordings from which the transcripts that you already have were created. You went on to say that certain members of this committee and the Oversight Committee are seeking contempt. You're aware that a majority of this committee has marked up a contempt resolution, aren't you, sir?
Certain members includes the majority, yes.
It's a big difference, isn't it, sir? Isn't that significant? The fact that a majority of the committee charged by the Congress to inquire into the grounds for impeaching the President of the United States has marked up a contempt resolution. That's more important than certain members, isn't it, sir?
Majority,
Institutionally, more important.
a majority has sought contempt, yes.
You said that you will not be intimidated. Are you the arbiter?
I'm sorry?
Are you the arbiter, the decider of whether or not those tapes will be provided to this Congress at the subpoena of its committee to investigate the president?
Constitution requires me to protect the separation of powers and our ability to do investigations in the future. It requires me, and the court proceedings make that clear, to weigh whatever interests you have against the interests of law enforcement. The president has asserted executive privilege, and I have not heard a legitimate legislative reason why the audio is insufficient for any purpose, the legitimate purpose.
You
have.
know what demeanor evidence is, don't you, sir?
I'm sorry.
Demeanor evidence. You know what that is. You sat on the bench for decades. You know
I know what demeanor evidence
Okay.
is. I know what demeanor evidence is, and I've not been shown any reason why audio evidence of demeanor would make a difference in any legislative purpose.
Well, that's exactly what demeanor evidence is, sir. Witnessing and observing a witness as they testify. And what can be done by this committee is to observe the audio recording of the president testifying to see whether it comports with the transcript or whether it reveals things about his capacity or his veracity or anything else that comes from his demeanor as he is interviewed.
Well, none of the things that you just mentioned are a legislative purpose. I haven't yet to suggest any law that you intend to pass or are thinking about in which the audio would make a difference over the transcript.
If a future DOJ concludes, well, let me ask you this question. What happened to Peter Navarro and Steve Bannon when they decided to defy a subpoena of the Congress?
We received 4 referrals, criminal referrals. 2 were prosecuted, 2 were not. The 2 that were prosecuted, as the published court opinions make clear,
What will happen to you if your decision is baseless?
May I continue to answer?
No, I know what happened. You know what happened too. Mr. Navarro's in prison. What will happen to you if your sole determination that you're not going to cooperate with this committee's subpoena is
With respect to the 2 people you asked, the court made clear they did not comply in any way, did not even appear, and second, there was no executive privilege. Neither of those is true in my case.
If a future Department of Justice follows the facts and the law, as you're fond of reciting, even to the point of prosecuting a former president, then if your decision is baseless, you should be prosecuted, right?
If a future, and I hope it will be the case, a future Justice Department follows the law and the decisions of the Office of Legal Counsel since the Reagan administration, when there is an assertion of executive privilege, the contempt statute is inapplicable. That's been the rule through every administration, including the Reagan administration. It even reached back to the Eisenhower administration.
Mr.
I
Attorney
hope
General,
they will follow the law.
Mr. Attorney General, you have resurrected the Foreign Influence Task Force, and there's a FBI spokesman who recently told media, according to reports, that FBI has returned to facilitating the sharing of information about foreign malign influence with social media companies in a way that reinforces that private companies are free to decide on their own whether and how to take action on that information. A district court has decided that you didn't do that before. How are you doing that? How are you reinforcing that private companies have their own capacity to decide?
The case that you're talking about is now under advisement in the Supreme Court of the United States, and I'm not going to comment on any court matter which the court may.
I didn't ask you to do that. I asked you to ask you how you're reinforcing it. That's what your spokesman said. You're reinforcing the private company's latitude. How are you doing that?
I'm not going to comment on what the district court said. We have the authority, as the Supreme Court just held last week, to persuade. We can't coerce. So we can provide information that Russia or China or Iran or North Korea is operating on a social media platform.
Why don't you do it in
And then
public?
we leave it to the social media to take it down.
Why don't you do it in public?
I'm sorry?
Why don't you do that in public so the public can see what you're doing?
Well, I'm not saying that we shouldn't also do it in public.
Well, I think
would
you
hope
should.
Everybody in this room would want to know if one of our adversaries is acting as if they were American citizens on a social
You're back.
media.
Time of the gentleman's expired. The gentlelady from Pennsylvania has a UC, and then we'll come to.
I have a brief UC unanimous consent request, and it follows directly in line with what was just being asked about. Chairman Jordan has argued that the committee needs this audio file of the President Biden's interview with DOJ, yet has refused to release the transcripts from the vast majority of more than 130 transcribed interviews that the committee has conducted to date. Even refused to provide copies of the audio and video files of the transcribed interviews and depositions.
Is there a unanimous consent request in here?
There is.
Okay.
I ask unanimous consent to enter into the record all of the transcripts, transcribed interviews that the committee has conducted this Congress so that we can bring that real transparency to the American people.
I object.
Gentleman from North Carolina objects.
And I thank you for releasing the one transcript.
We will
Nina
release all the
Jankowicz,
transcripts when we
well, one
complete our
day after I
investigation.
asked for it, you did
They've
release
completed their
Nina.
investigation. They won't give us all the evidence. We will give all that evidence when we're done with our investigation. The gentleman from Pennsylvania is recognized.
Thank you.
Attorney General Garland, over here.
Thank you.
Thank you for your long-standing and honorable service to our country and for being here today. The American people appreciate the serious work that you and the dedicated members of the Department of Justice do on their behalf every day to protect the rule of law and to protect our communities and our civil rights. Congress, of course, has a legitimate duty to oversee the department's functions, but it's pretty clear from the remarks we've heard from our Republican colleagues in this hearing that they have not brought us here today in pursuit of that duty. Instead, this hearing appears driven by the desire to curry favor with the disgraced, impeached, indicted, and now convicted former president and their ongoing efforts to legitimize his attacks on American elections, our judicial process, law enforcement, the press, and basically anybody who contradicts or seeks to hold him accountable. So this isn't legitimate oversight. It's political theater, and it's pretty bad theater at that. It's not the serious work that the American people should expect us to do here, and it distracts from our understanding and oversight of the Department of Justice's important efforts to protect our national security, to combat violent crime, gun violence, drug trafficking, and fraud, to protect voting rights and reproductive freedoms, to combat hate crimes, and to advance environmental justice. So I would highly recommend that anyone who is actually interested in the Department of Justice's work to read the statement that you submitted to the committee today, because it contains some important details about the work that the department is doing. I was particularly struck and profoundly troubled by your comments about the extraordinary rise in threats and violence against public servants in our country, ranging from criminal threats against election workers and members of Congress to the January 6th assault on this Capitol and our constitutional order. So I'd particularly like to focus on one aspect of those attacks on public servants, and one that has implications for the strength and future of our democratic republic. I'm interested in the Department of Justice's work to protect those who implement and defend our elections. Because in the wake of the 2020 election and in response to the lies and conspiracy theories embraced by the former president and his lackeys, we've seen election officials and poll workers across the country. These are apolitical employees, they're community volunteers, retirees, neighbors, civic champions. They've become targets for threats and violence when they stand up against the lies and seek to hold the former president accountable because they did their jobs running our elections. And to the extent that these lies and conspiracy theories have been embraced or elevated by members of this Congress or committee, shame on them. This isn't legitimate political discourse. It should not be part of our American public life because words do have consequences. When leaders embrace misinformation, that's dangerous. And when they fail to defend our elections from lies and misinformation, that's dangerous and cowardly. Now, this committee has heard testimony from multiple witnesses, experts in election security who've expressed concern that threats to election workers, which exploded in 2020, will result in fewer people being willing to serve, and whether as nonpartisan employees or volunteers. Attorney General Garland, can you comment briefly on the incidents of threats and violence against election workers, why these incidents are dangerous, and if you have any insight on what's caused this dramatic rise?
So your portrayal, I think, is quite accurate. I've been worried about this since 2021, and I've been talking about this with our United States attorneys. We created an election threats task force, particularly because we were so worried. And as you say, this is not only about elected election officials, not only about appointed election officials, but about ordinary Americans who show up as poll watchers on a single day during the year to run our elections. Our democracy can't work if those people fear threats that are urged against them or if there's actual violence against them. We have brought, I don't have the exact numbers, but I think it's creeping up on 20 cases where there have been extraordinarily graphic threats of violence against election workers, and we have received some pretty strong sentences in those cases. Of course, we always balance First Amendment right to criticize, to disagree, but when somebody makes a threat to kill an election worker, to kill members of their family, we respond, and we are going to respond aggressively. Every U.S. attorney has endorsed this position. Every FBI field office has an election security agent whose job it is to be sure that threats against election workers are investigated, deterred, and prosecuted.
Thank you. And if there are additional tools that Congress can provide that would help the department in this work, I'd appreciate hearing about it. I see my time has expired. Thank you for your testimony.
Generally yields back. The gentleman from Oregon is recognized.
Thank you, Mr. Chair, and thank you, Mr. Attorney General, for being here today. I just have a couple of areas of interest to me, at least. The first one has to do with your remarks earlier in the hearing where you were drawing the distinction between state court and federal court, and you were saying that state court is, quote, another jurisdiction. State, quote, prosecutors are independent. Third remark, prosecutors are completely independent. Fourth remark, action decisions of the state prosecutors are independent and they are taken of their own volition. What disturbs me about those assertions is what actually happened. I'll go with the Fani Willis case first, and just mentioned that her friend spent some 8 hours in the White House discussing the case. Her friend, Fani Willis's friend. And my question to you is, if they're so independent, why were people who were involved in this state action up talking to the federal folks? How do you explain that?
Well, I don't know if it's true. I don't know anything about that. I don't know if she was there, what she was talking about. I don't know anything to support this allegation at all.
I think what I have here on my notes are, were you aware that the Fulton County DA, Fani Willis's office, coordinated with Special Counsel Smith, the Biden White House, and the Democrat-run January 6th committee during her investigation of President Trump? You're saying you don't know anything about that?
Yes, I don't know anything about that, no.
Would it disturb you if that actually happened?
Well, I imagine that if this committee asks a prosecutor for information, or if a prosecutor asks this committee for information, there may be conversations about that information. I think that is relatively routine. I don't have any idea whether there were any conversations with the special counsel, but it would not be anything wrong with people in different jurisdictions who have evidence obtaining the evidence.
Were you aware that DA Willis hired her friend Nathan Wade to prosecute President Trump as Mr. Wade met with the Biden White House on 2 occasions for 8 hours?
I don't know anything about it.
You know, again, would that disturb you? And the reason I'm asking this is because it appears that there is this double standard. Some people refer to as a two-tier system. That is, one tier for certain people like President Trump and the other tier for everybody else. And that disturbs me. Would it disturb you if there was a different type of justice being applied to our former president than that which is applied to other defendants?
Of course it would disturb me. There is only one tier of justice. We treat like cases alike. We don't give any benefit to a powerful person over a non-powerful person, any benefit to a Democrat over a Republican.
I'm not concerned about the defendants getting the benefits so much as I am the prosecutors in state court coming to the federal folks and basically saying, hey, we know you've been doing all this work here, give us all this material. Now, maybe that much is fine, but that isn't what generally happens. Now, if you were a former president, you're going to get a lot of attention, and that's exactly what's been happening here. And I don't think that's fair. I don't think the people of the United States think it's fair that a former president would be ganged up on, if you will, by both the federal government and the state government. That does not seem right. Now, you may be doing it, and I guess you're saying that it would be fine if that did happen. But to me, it seems like a double standard. I want to shift over to the audio tapes. And you're a former judge, so you're very familiar with the best evidence rule. It's Rule 1002. And I went to law school. I remember the discussions about, quote, best evidence, but you would know it far better than I. You must have dealt with it literally hundreds of times. But the best evidence rule to we rural practitioners of country law meant that if you had one piece of evidence, well, I know an audio tape, you'd be far more likely to want to use it, and perhaps it would be required as opposed to a transcript. Is that correct?
I respect your experience, but I'm afraid the best evidence rule is not applicable. Best evidence rule is reflected in Rule 1003 of the Federal Rules of Evidence, and it provides that a duplicate is admissible for all purposes as an original unless there is a genuine dispute about its authenticity. For the reasons I've stated extensively in answers to the other members, there is no genuine dispute about the authenticity of the transcripts. So the best evidence rule simply has no application in this case.
So actually, I would agree with you in the sense that we're not in federal court, and but I also want to tell you that when the essence of his decision, Mr. Hur's decision, was that there was a challenge that our president is facing when it comes to his memory and his demeanor, then I have to agree with the gentleman from North Carolina that the audio tapes are the best evidence of exactly how qualified Mr. Hur was in making his decision that he should not prosecute. With that, I see my time is exhausted, so I yield back.
Gentleman yields back. The gentlelady from Pennsylvania is recognized.
Thank you, Mr. Chairman. Hello, Attorney General Garland. I thank you for being here today. I thank 115,000 members of the Department of Justice for your faithful service. And I am sorry for the regrettable conversations that are going on. I've served on this committee for the better part of 6 years. I begged to be on this committee when I ran. There was so much I wanted to work on, like focusing on gun violence, like focusing on the opioid poisoning epidemic, and so many other things having to do with the protection of civil rights and the rule of law. And yet what we've observed in this committee in hearing after hearing after hearing, sadly, is misinformation, disinformation, very pointedly with the purpose of tearing down America's faith in our institutions. This is one such hearing. There are members on this committee who would rather tear down the faith in the independence of the Department of Justice than say that one man is responsible for his behaviors and is being held to account, both civilly and now criminally. Mr. Trump's behaviors are the reasons they are railing and they are upset. He's been found guilty of fraud. He's been convicted on 34 felony counts. And it would be okay if it weren't so dangerous. That's what worries me. It is so dangerous what is going on. So let's be clear. One of the reasons that you're here today is to say somehow the Department of Justice had something to do with the Manhattan District Attorney bringing the suit and a jury of 12 citizen strangers listening to the evidence, hearing from talented prosecutors and defense attorneys and the judge, and they came back with the clarity of 34 convictions for a former president and a presidential nominee. What role did your department have in that prosecution?
That prosecution was determined by the Manhattan District Attorney, which does not report to us, is not controlled by us, and operates completely independent of the Department of Justice.
Thank you. I also want to respond to a few other dangerous statements. Chairman Jordan said a kangaroo court, that's quoting, convicted President Trump. He's the chairman of the Judiciary Committee. Speaker Johnson's claimed that Democrats cheered this purely political exercise, and we heard him in an interview on Fox saying the Supreme Court should break up the conviction, overturn the conviction, and he knows many of the justices personally. Mr. Trump pities himself as a so-called political prisoner. These statements are false, and they are aimed to mislead, they are aimed to inflame, they are dangerous. The nominee is a convicted felon, or the would-be nominee is a convicted felon. What happened is he was guilty of an unlawful conspiracy to win the 2016 election by falsifying records to cover a tryst with a porn star in the days before the 2016 election. I'm grateful our institution stood up. I'm grateful to that set of jurors who walked in as strangers and citizens and listened to the evidence and put the law attached to it. But I'm really deeply concerned that our institutions are under attack. Mr. Garland, you talked about in your written testimony the role of the Department of Justice in upholding the rule of law. Can you speak to that a little more?
So I have devoted my entire career to ensuring that the rule of law is the rule that the Justice Department applies and that the courts apply, that we follow the precedents, that we treat like cases alike, that we do not have enemies or friends, that we do not pay attention to the political parties or the wealth or the power or the influence of the people that we are investigating, that we follow the facts and the law. This is what distinguishes this country from our adversaries. And an attack on the rule of law tears down people's confidence in the basic fundamental element of our democracy, that all people will be treated equal. And I intend to continue to protect the rule of law, to protect the 115,000 career employees of my department, to make sure that they can continue to go about their job, which is to do the right thing every day and not to be distracted by outside influences, political or otherwise.
I thank you, Mr. Attorney General, and I call upon those.
Gentlelady's time.
I want to just mention one other thing.
Quickly.
I'm fearful for the appalling silence of good people on this committee.
Okay.
We've heard enough.
Gentlelady's time has expired. Mr. Attorney General, we understand you want to break. Can we do one more 5 minutes and then we'll take a little break? Would that work? All right, the gentleman from Texas is recognized.
Thank you, Mr. Attorney General, for appearing before the Judiciary Committee. I read a report recently that the D.C. United States Attorney's Office had only devoted 5% of resources to January 6th prosecutions. But I've also understand from many conversations that the most or all of the United States U.S. Attorney districts contributed an AUSA or an investigator to the effort. Can you confirm whether the department across the board has been providing additional support from other U.S. Attorney's offices in terms of AUSAs or investigators contributing for the January 6th investigations?
Yes, that's true, and that began before I became Attorney General. That continued after I became Attorney General.
So multiple resources across the department have been devoted to that effort, including other districts?
Yes,
okay.
Because of the significance of an attack on democracy in this body.
The reason I'm asking about that is in terms of the focus of the resources of the department. If staff would put up on the screen, there's a number of people here that I want to see if you can identify who they are. What we have here in the bottom right-hand corner is a woman named Lizbeth Medina. She was found dead in a bathtub in Texas. Her mom found her, hoping to see her in a parade that night. She was killed by Rafael Govea Romero, who was here illegally. On the bottom left-hand corner, you have Lake and Riley. She was killed by 26-year-old Jose Ibarra, arrested by U.S. Customs and Border Protection after he unlawfully entered the United States near El Paso, Texas. Up above, you have officers Richard Uruso, 26, and Officer Christopher Abreu, 26. Both were shot this last weekend by Bernardo Raul Castro Mata, a 19-year-old Venezuelan national apprehended by U.S. Border Patrol after he unlawfully entered the United States near Eagle Pass in July of 2023. What we have is a continued effort by the federal government to fail to secure the border of the United States, and Americans are dying or getting shot. In this case, law enforcement getting shot, 2 young women who are dead. My question for you with respect to the department is, do you believe that Texas has a right to defend itself and to ensure that people who are in this country are not here illegally, and that we can protect the citizens of Texas from people unlawfully here who are committing crimes to Elizabeth Medina, who's no longer with us because the federal government refused to do its job? Yet the Department of Justice is suing the state of Texas to stop implementation of SB 4. So do you say, as the Attorney General of the United States, Texas does not have a right to defend itself and to protect our citizens from murder by people who have come here illegally into the United States?
I say, as the Attorney General and as a human being, that my heart goes out to the families, that these are terrible, terrible events. And I say, secondly, as the Attorney General, the way to stop people like this from coming into the United States is to give more resources to the Border Patrol so that they can prevent
Mr. Attorney General, no. No.
You don't want to
We the people of Texas, money's not going to solve the problem when the Department of Homeland Security and the President of the United States refuse to enforce the law, ignore the policies, and Lizbeth Medina would be here alive today if we were following the law. Lake and Riley would be here today if we had not released a killer onto the streets of the United States of America through parole policies that this administration is advancing. And the Department of Justice is suing the state of Texas in court, taking valuable resources to go against the people of Texas, when Texas simply wants to say that we should have a say in stopping people who are illegally, arrest them, and be able to deal with that on our own terms when the federal government refuses to do its job.
As reflected in our filings in that case, we are in court because the United States Supreme Court in Arizona versus the United States held that states cannot adopt their own immigration.
You're in court because you're choosing to try to stop Texas from enforcing the laws that the federal government is refusing to enforce. And by the way, that's not the same thing as Arizona. But a final question in my last minute. The Department of Justice did not assert privilege with regard to the transcript, correct?
That's right.
And you articulated a minute ago to my colleague that the best evidence rule says that the transcribed copy is admissible, right? But how can you claim privilege in the face of not just a legislative inquiry, but a constitutional impeachment inquiry? How can you claim privilege for something that you just testified was effectively the same thing? How can you claim privilege for the audio of the transcript you just testified was the same?
I just testified the words are the same. Sensing an audio is different. You have not given any explanation, and there's nothing in the impeachment resolution that would make a difference with respect to audio.
I respectfully disagree. I would ask you one last question. Is the decision not to prosecute President Biden for effectively the same crime for which DOJ...
Gentleman yields back. The committee will take a short break, and then we'll be back in 10 minutes, 5-10 minutes.